Okay, good day, class. Today we will talk about Article 11 and 12, the justifying and exempting circumstances, or circumstances which justify or exempt a person from criminal liability. Now we have Article 11 of the Revised Penal Code, the justifying circumstances. Now, under Article 11, there are 6 instances wherein, um, when these circumstances are present, you will not incur criminal liability. Now, what are these acts? So, number one, we have acts in the defense of your own person or right, that is self-defense, and then acts in defense of the person or the rights of relatives, that is the defense of relatives, acts in defense of the person or rights of a stranger, that is defense of stranger, acts which cause damage to another in order to avoid an evil or injury, or that is a state of necessity or avoidance of greater evil, is the fourth one. The fifth is acts in fulfillment of a duty or in a lawful exercise of a right or office. And then the last one is acts in obedience to an order issued by a superior for some lawful purpose. Now, how can one person say that he is acting in number one, the first circumstance? How can he or she say that he is acting in self-defense? So there are 3 requisites in order for the act to be considered self-defense. First, there must be unlawful aggression. What do you mean by unlawful aggression? No, it's a physical act manifesting danger to life or limb. It's either actual, meaning the aggression is already there, and it could also be imminent, meaning dili na mapugan. It will definitely, the aggression will definitely happen. So first, again, there must be unlawful aggression. Second, um, the reason second requisite for self-defense is reasonable necessity of the means employed to prevent or repel it. So meaning, the act that you did in defense of against the unlawful aggression must be reasonable. No? So for example, a person attacked you with a knife, then you can say that the reasonable necessity of the means employed, you cannot attack the same person with a gun. No, because uh, it should be proportionate to the force of the aggressor. So kung knife, either knife, kung gun, dili na reasonable necessity. No, it is more than, no, more than the force of the aggressor. Therefore, the requisite for reasonable necessity of the means employed to prevent or repel it shall be missing. And then the third one is lack of sufficient provocation on the part of the person defending himself. Meaning, dapat the person acting in self-defense should not be the first aggressor. Meaning, dapat wa siya nag-una-una. Because if the person acting in self-defense was the first aggressor, or there was provocation on his or her part, then the third requisite for self-defense shall be lacking. So those are the requisites for self-defense. Okay, so there is also another instance for self-defense under RA 9262, Section 26. RA 9262 is the Anti-Violence Against Women and Children Act. There is what we call battered woman syndrome. That is another form of self-defense. So, from the name itself, battered woman syndrome, if a woman who has been abused over and over, has been went through a cycle of abuse, and he fought back against her aggressor, either her partner, her husband, her boyfriend, her ex-boyfriend, ex-husband, ex-partner. Then she could invoke uh, the battered woman syndrome as a justifying circumstances in order not to incur criminal liability. But in order to claim the defense of battered woman syndrome, the battering cycle, meaning the violence, must occur at least twice in their relationship. So, dili ra kay na dapatan ka usa, igbawas patjo na, no? So, that is not considered a defense as falling under the battered woman syndrome, because there must be at least two cycles in order to create the battered woman syndrome. Now, the next kind of defense, next kind of justifying circumstance is defense of relatives. So, who are your relatives? So, number one, your spouse or your husband and wife or wife. Second is your ascendants. Your ascendants are your parents, your grandparents. Third is your descendants. It could The descendants are your children, of course. And then the fourth, we have your legitimate, natural, or adopted brothers or sisters. And then we have your relatives by affinity in the same degree, meaning up to the second degree. So your in-laws, mother-in-law, father-in-law. So, and then lastly, your relatives by consanguinity within the fourth civil degree. That is it includes your aunties and your uncles and your first cousins. So these are the persons, if ever you would defend them, it would fall under defense of relatives. Now, what are the requisites in order for the defense of relatives to be considered a justifying circumstance? Again, there must always be unlawful aggression. Second, the reasonable necessity of the means employed to prevent or repel it, just like the first two requisites in self-defense. However, the third is, in case provocation was given by the person attacked, the one making a defense had no part in it. Meaning, pwede nga it is your relative who started the aggression, or there was provocation on the part of your relative, meaning mo relative ang naguna-una, basta the person acting in the defense of the relative did not take part, no, wa siya ning appeal sa pag-provoke or pag una-una sa aggression. So mo na mag-differ sa self-defense and sa defense of relative. The third requisite, against self-defense, there must no provocation on the part of the person acting in self-defense. In the defense of relatives, even if there was provocation on the part of the relative, it is still justifying as long as the person defending the relative did not take part in the aggression or provocation. So that is the defense of relatives. So what you just need to remember in this justifying circumstances are the relatives who are entitled to defense. So there are six. No, there are six, as I have mentioned earlier. Now, the third kind of justifying circumstance is the defense of stranger. So, who are strangers? These are any persons not included in the enumeration of relatives mentioned in paragraph 2 of Article 11. Okay, so if it is just your boyfriend or girlfriend or your um, common law spouse, meaning live-in partner, then it falls under the defense of the stranger, or it is your illegitimate brother or sister, then it falls under the defense of stranger. So basically the same requisites, the first two requisites, unlawful aggression and reasonable necessity of the means employed to prevent or repel it. Now, the third requisite, in order for the act to be considered a justifying circumstance, is that the person defending be not induced by revenge, resentment, or other evil motive. So meaning, ikaw nga ning act in the defense of stranger, your motive is really to help and defend the stranger, not because you want to revenge or nakikasuko to the person who to the aggressor. No, so meaning the motive in defending the stranger should be just to help and defend the stranger. So, very simple ra ang defense of stranger as long as ang person dili mo fall sa enumeration sa relatives, then automatically ani siya mahog sa defense of strangers. And then the fourth one, this is quite different from the three. This is the state of necessity or the avoidance of greater evil. So, it exists no when, for example, you are driving a car, na you are driving a car and then nawala ng brake ang imong sakyanan. So, sa road, kung di money ka sa left, mahagbong ka sa pangpang. If money ka sa right, madasmagani mo ang mga naninda sa kilid sa daan. So it is the instinct of a person to preserve, no? There is always the instinct of self-preservation. Gusto jud ta mabuhi. So most likely papilion ka mahagbong ka sa pangpang or modasmag ka diri sa mga naninda sa kilid sa daan, anhi jud ka modasmag sa mga naninda sa kilid sa daan. So if it resulted to damage, you can claim justifying circumstance in order not to incur criminal liability. Now, what are the requisites under this state of necessity or avoidance of greater evil or injury? Number one, the evil sought to be avoided actually exists. No? Meaning, from our example, nawala naman og break and the evil sought to be avoided is death, no? So, mupili ka, ani ka sa left, pang-pang, mamatay. Ani ka sa right, makadasmag ka og mga tao. So, there is, the evil sought to be avoided is death. And then, the injury feared be greater than that done to avoid it. So, ang injury, if dili ka sa left, is mamatay ang person. If dili ka sa right, makaguba ra ka sa mga tindahan. So, of course, greater injury ang death. And then there be no other practical and less harmful means of preventing it. Meaning, wala na kay choice. It's either ang greater injury or ang lesser injury. And you chose lesser injury. So, if makomplete ang tulo ka acts, then that is considered a justifying circumstance. And then the fifth kind of self-defense is fulfillment of duty or lawful exercise of a right or office. No? So this is very applicable, especially to you criminology students, because sooner or later you will become police officers or law enforcers. So you could use this defense, no? When you are in duty. So what are the requisites, no, in order for an act to be considered a fulfillment of duty or lawful exercise of a right or office? First is that the accused acted in the performance of a duty or in the lawful exercise of a right or duty. Then second, that the injury caused or the offense committed be necessary consequence of the due performance of duty or the lawful exercise of such right or duty. For example, no, a police officer is justified in shooting a criminal who refuses to stop. Now, for example, hot pursuit. The police is acting in hot pursuit in order to capture the criminal, and then warning ng a gunshot, but despite the warning gunshot, the criminal did not stop. If the police officer will shoot the said criminal, um, he is justified. No, he will not incur criminal liability under the fulfillment of duty. So, given the fact that the police officer is actually on duty and he is part of the operations, di kay na mo sila put for whatever reasons. So, um, that is under fulfillment of duty or lawful exercise of a right or office. And then the last, what do you call this? The last justifying circumstance is obedience to an order issued for some lawful person. Now, this is also applicable to law enforcement. Uh, if the act was if the act done was in obedience to an order issued for some lawful purpose, then you cannot incur criminal liability. Now, what do you call this? Requisites. Now, what are the requisites? So, an order has been issued by a superior, and such order must be for some lawful purpose, and the means used by the subordinate to carry out the said order is lawful. No, so for example, we don't have a shoot to kill order. No, for example, there is an order to capture a wanted person, and of course, uh, such order is lawful, and so the order to capture a wanted person, and then the wanted person just ran out, no? Nagpagukod-pod siya sa police officers, and um, meaning the means used to carry out the order is lawful, meaning allowed naman gihapon, no, to shoot, especially if in hot pursuit. So, ang difference sa number 5 o sa number 6, sa number 5, you are fulfilling your personal duty. Sa number 6, there is an order issued by a superior. But basically, medyo they are related. So those 6 acts are considered justifying circumstances which, if a person completes all the requisites, he will not incur criminal liability. So, in a justifying circumstance, the act itself is not criminal. No, it is not. It is not considered a criminal act. Okay, that is why there is no criminal liability because the act is considered lawful. That is for justifying circumstance. But when you talk about exempting, no, exempting circumstances, the act is unlawful. The act is a criminal act. However, the person doing the act is exempted from criminal liability. So that is the difference. Sa justifying circumstance, the act itself is not considered a criminal act. In exempting circumstances, the act is a criminal act, but the person doing it is exempted from criminal liability. Now, who are those persons exempted from criminal liability? So first, we have an imbecile or an insane person. So when you say imbecile, that is a what do you call this? That is a person who is already advanced in age, meaning tiguwang na siya, but ang isang maturity, ang isang huna-huna is comparable to a 2-year-old, 2 or 2 to 7 year old nga child. So, mature person, but ang panguna-una is 2 to 7 years old. That is what you call an imbecile person. Or the person is insane. So, when you say insane, generally, Bisaya, buang, no? But meaning there are psychological, what you call, uh, psychological problems which deprive the person of intelligence or reason, or dili sila ka huna-huna what is right or wrong. So an imbecile or an insane person is exempted from criminal liability because of the absence of intelligence. They cannot distinguish right from wrong. How However, there are instances wherein an insane person can be criminally liable when he is acting in lucid interval. So what do you mean by lucid interval? There are instances a schizophrenic person dili siya mo andar, no? Meaning na mga adlaw or mga oras nga dili siya buang. When the criminal act was done during the time nga dili siya buang, tarong siya, but then later on nabuang na po, then the person is um, criminally liable. Liable siya because he acted during lucid interval. Meaning, maka-difference sa time ni iyang nabuhat ang criminal act, he can differentiate what is wrong and what is right. So, that is the first person exempt from criminal liability, an imbecile or an insane person. So, what are examples of insanity? We have schizophrenia, ang kaning schizophrenia, um, they are psychotic na sila, no? They cannot distinguish uh, reality from fantasy. So, mo na sila schizophrenia. We have the kleptomania, or the presence of abnormal, persistent impulse or tendency to steal. Epilepsy can also be a form of insanity, wherein there are convulsive motions of muscles and loss of consciousness. Pwede sila makover sa term nga insanity under our criminal law. But when a person claims insanity, no, the accused should prove that he is actually insane. No, it is not the prosecutor who will prove that the accused is insane, but it is the defense who will prove that the accused is actually insane. Okay. And then we have, okay, so those are examples of insanity. And then the next person exempt from criminal liability is a person under 9 years of age. So meaning 9 years old pa ubos. So naman yung mga bata no nga makakommit og mga criminal acts. These are what we call CICL, children in conflict with the law, the juveniles. So if a person is age 9 years old and below, even if he committed criminal liability, then um, he is not criminally liable because no kana that age no, again they cannot distinguish right from wrong. There is no discernment. Okay, the third person exempt from liability is over 9 years old but under 15, no? So 9 that under over 9 years old, that is 10 years old, 10 to 14 years old. No? Kung between 10 to 14 years old, exempted gihapon from criminal liability. No? However, um, if the child, no, child pa man dyan na sila, if the child acted with discernment, meaning kasabot siya nga what he is doing is wrong, then he could be criminally liable. So how can we say that the child was acting with discernment? No, it depends upon the circumstances of the crime when the crime was committed. So kung kasabot ganing ang bata sa iyang gibuhat, and it can be shown through the circumstances that the child indeed acted with discernment, then he would be held criminally liable. So again, that is 10 to 14 years old. Ang kanang 15 and above, 15 but less than 18, that falls under a different circumstance and is mitigated circumstances or mitigating. And then the fourth reason for exemption from criminal liability is when a person is performing an act causes an accident. No, so when the act is caused by an accident, then obviously, no, what man to do, then he would not be held criminally liable. Criminally liable. Okay. So dapat, in order for the act to be considered an exempting circumstance, the person must be performing a lawful act and in the exercise of due care, meaning kanang isa gadyong what do you call this? He was not negligent in doing the act. However, despite that, nakakos gihapon siya og accident without any intention to do so. Okay, so if the act is considered an accident, then you can be exempted from criminal liability. And then another is when there is irresistible force. No, so for example, uh, there is what are the requisites now in order for the act to be considered an exempting circumstance under irresistible force. No? So number one, there is compulsion by means of physical force, meaning kanang sani gitiunan jud ka, for example, and then the physical force must be irresistible, and the physical force must come from a third person. So for example, you were walking and then gitutukan ka og pusil sa imong kilid, and giingnan ka nga if dili ka mangawat sa bank uban atong tawhana, ikaw mismo ang mukuha sa kwarta, then isa kang pusilon. So that is considered an exempting circumstance under irresistible force because gipugos lamang ka because of a physical force coming from a third person. So that is irresistible force. Next is uncontrollable fear. So unsa may difference sa uncontrollable fear o sa irresistible force? Sa irresistible force, the compulsion is physical. No, sa uncontrollable fear, there is a threat. There is a threat which causes fear of a greater evil than which is required to commit, and it promises an evil of such gravity and imminence that an ordinary man would have succumbed to it. So, for example, katong gihapon, robbery in a bank. Now, for example, wa ka gitiunan, but gitawgan ka nga kay gikidnap ang imong family, gikidnap imong wife or gikidnap imong children, and nanawag sila nga if dili ka mangawat ani nga bank, then we will kill your wife or your child or your children or your parents. So you are forced by that uncontrollable fear to commit the criminal act. No, like, of course, an ordinary man would succumb to it, especially if na-missing na imong mga bata, yung gitawagan na ka, you can hear the voices. So, there is uncontrollable fear, then you have to commit the criminal act. So, you can be exempted from criminal liability. Okay, and then the next the next exempting circumstance is when the person is acting by a lawful or insuperable cause. No? So, um, okay. So when you say the act is considered a lawful or inseparable cause, the requisite is that the act is required by law to be done, and then the person fails to perform such act, and his failure to perform such act was due to some lawful or inseparable cause. For example, um, a priest, no, a convicted murderer confessed to a priest, and then the priest, under their vow of secrecy, cannot reveal the confession. So even if he is asked to testify against the murderer, he cannot do so, even if the act is required by law, and he will fail to confess, he will fail to reveal the confession because of a lawful cause, because of their vow of secrecy. Then, therefore, the priest cannot be considered an accomplice or an accessory of the criminal act or of the accused. Okay, so that is an example of a lawful cause. So again, those seven are those seven circumstances are the exempting circumstance, or meaning you cannot be held criminally liable. So again, in an exempting circumstance, there is a crime, but there is no criminal, because uh, the actor, no, of the crime is not criminally liable. However, in justifying circumstance, there is no crime because the act is considered lawful. So that is what you call um, that is Article 11, justifying circumstance, and Article 12, exempting circumstance. Thank you for listening.